very irritating for Mr. Colt's, almost like, you don't own this. You have to ask for permission to come on this land anytime.
This easement, it needs to be open 24 hours a day. Then when I hear people kind of nitpicking, I really don't like that. I'm not going to tolerate this. This comes back before me. I'm not going to be as gentle. Make a finding of contempt. I'm going to impose $1,500, holding in advance another $15,000 as a motivation.
This one is a little different, so here is the quick backstory. The plaintiff is a landowner in the Pacific Northwest where timber harvesting is big business. He sued the defendant to enforce an existing easement that allows logging personnel and equipment to use a road through the defendant's property to reach his own land. Today, after seeing the defendant's continued obstruction and refusal to comply, Judge Evans hauled Mr. Spencer back into court and imposed consequences. Let's roll those.
I'm Judge Evans, and we have Mr. Fry and Mr. Conway, respectively representing the BT Culp and Spencers. We're on for two matters. One is the motion for entry of judgment, and then also there's a motion for show cause regarding the contempt. So those are the two issues that I think are pending before the court today. Are the parties in agreement that that's why we're here?
Yes, Your Honor.
I received Mr. Conway's proposed judgment, so I'm ready to proceed however the court likes.
So Mr. Fry, you also submitted a proposed judgment, correct?
That's correct, Your Honor. I think there was an issue with the satisfaction of judgment. I've already signed one. We just need to fill in the date that the judgment is filed, and then we'll go ahead and file that.
Okay, and that's in reference to the judgment that was prepared by Mr. Conway?
Well, I'm trying to determine the difference. They look similar. I think his is one more point than mine, but we filed a proposed judgment on December 15th.
You know, if there's no huge objection, I just propose we enter that. And then I would like to address, when the court's ready, this issue with the satisfaction of the judgment and the recording and whatnot.
Okay, thanks. Mr. Fry?
That's fine. They look the same to me. His has one more, and I think it's kind of a redundancy, but it's fine with me for the court to sign off on his and enter that Mr. Conway's proposed judgment.
Very good.
We will go ahead and file a satisfaction today.
Okay, that's great. So I've signed off on the proposed judgment that was submitted by Mr. Conway. I've just changed the date that was on there from the 5th to the 19th. And I'll just put Mr. Conway signed this one, and then Mr. Fry, is it okay if I put, what would you like on your signature line? Present via Zoom or other?
Sure.
Right, we'll do that.
Agreed. I don't know.
All right, good. All right, so I've signed that. And then the issue regarding the satisfaction of judgment, I think Mr. Fry, you indicated that you'd be recording that.
We can record it, Your Honor. I hadn't thought about that. Typically, I record the judgment, and I don't record partial or full satisfactions because RCW on the satisfaction of judgments just says that once the clerk files it, it's presumably satisfied for everybody. And so I haven't been recording satisfaction of judgments. I don't know if it makes. I guess it's just an added cost to my part, like my client, Mr. Spencer, could record it.
Okay. Mr. Conway?
Yes, Your Honor. My I guess concern is twofold. You know, typically with a judgment, especially a low dollar amount like this, you know, we've already paid it. A lot of times you don't even enter it. But I think we've already argued that. If you do enter it, often you don't record it if it's paid right away. The issue here that I think is created by the plaintiff is that they insisted upon the money judgment, which has already been paid, in the same judgment document as the findings of fact. We need to record either this judgment or the findings of fact. I'm assuming this judgment because it's the last one, because we need to have all this restrictions of the easements and the court's rulings of how the parties are to proceed, bound to those parcels. Because I get the prior argument was made, hey, well, you could just search the names of the prior owners and this court proceeding would come up, but that's very difficult. And then as you go forward in time, that just becomes harder and harder as these properties transfer title to different owners. So I think we would do our clients a huge service and all future owners if we recorded the judgment document. if that's done, we would just like the satisfaction of judgment also recorded. So if you just pull up the property, it shows this judgment on it. You don't have to guess or get into these thorny title issues later. It's just the satisfaction of judgment comes up. So easiest way would just be to record the findings of fact. But if we record the judgment, we would just ask that the satisfaction of judgment be recorded as well. And if we need to say, hey, Spencer pays for the recording of the judgment, BD Colt pays for the recording of the satisfaction, I think that's fine. We don't have any control over that satisfaction. That's something they have to provide. So I just wanted to clarify that, and we'd be happy to split those costs.
Okay, thanks. Mr. Fry?
That sounds fair enough to me.
Yeah, me too. Let's do that. So both documents will need to be recorded, the judgment and then the satisfaction of judgment. And just for clarity, we'll have Mr. Cope take care of the paying for the judgment, and then the satisfaction will be Mr. Spencer. So we'll have Mr. Spencer pay for the judgment recording, and then the satisfaction paid by Mr. Cope.
Okay.
That's fine with me. We'll work with.
And I'll send counsel a copy of the recorded documents once I get it back from the court.
And then let's move next to the motion for show cause. So I know that there was some objection from Mr. Conway based on kind of procedure. And I thought about that, recognizing that there's not necessarily an order to show cause based on the motion that would bring us to this hearing here today. Having reviewed the motion, I think there's enough to put it forward to an order to show cause and to be here today. So let me ask you this. There's allegations that the findings of fact and conclusions of law haven't been followed. And then I read declarations from Mr. Spencer's expert that says there's just one tree that's in the way versus Mr. Heiner's, Mr. Kolb's expert says 16 are in the way. Is in the declaration of those two, is that if it's decided on declarations, do you feel, because there's a declaration by Mr. Kolb also, do you feel like there needs to be, your client needs to provide some type of declaration in addition?
Not on that point, Your Honor, because I think that's within the court's order. I was more concerned with the expert report started to talk about removing the water berm, and that's something the court has already decided. And so, in my opinion, that would they should have appealed it or something, presented the evidence at trial. So that issue was of concern. I don't think there's proper foundation for that. And my concern there is he's not trying to prohibit anyone from accessing the property. I know my client has some logs and things up. There's that cliff he put logs around. We're okay moving those for the logging truck. We're okay, the court deciding the issues with the trees today. So I think if that makes any sense, I think those issues I'm not going to belabor it with additional testimony.
If we can proceed today. All right. So Mr. Fry, I'll hear from you. From what I understand, I just have a listing. It looks like there's 6 issues that are of concern to Mr. Kolb. One is the corner by the gate. There's a log placement that restricts the width to 19 feet, not the needed 26 feet. That's one issue. Second issue, there's a soft edge where the gooseneck flatbed is parked and the flatbed truck is parked. That doesn't necessarily allow safe passage. The third, I put NA not applicable, and I can't remember what that was. And then there's a 4A and 4B. The 4A is the berm, and the 4B is the white truck near the roadway, causing too tight of a turn as alleged. Then there's a steel beam that's within 11.5 feet, allegedly, not the 12, and there's a soft edge next to that can't support it. And then the last one was the trees and the height. So those are the items.
So yes, Your Honor, you're pulling those off of the hinders.
I think so.
Okay. Yeah, a client, BD Colt here, that needs to use this road for logging equipment and timber management, and he can't. And so that's why we took the lawsuit all the way to trial to prove there was, in fact, an easement. and the ruling was for that the roadway be sufficient for commercial logging vehicles, and so that is with accepted logging practices. And so what we did is we took your letter to Mr. Henners, and they would be the one would be removing the timber products, and as we go along here, and so they want the road the safest for their companies, and so that's why we had the Henners report done to kind of make that consistent with your ruling, so we can get this work done and get a log truck up there. And that's mainly why we're appreciating having a court hear this today. There's the interfering with and obstructing has been very irritating for Mr. Culp and the company, because the parking vehicles, it's almost like you don't own this. You have to ask for permission to come on this land anytime, and then I will move the vehicle. And that's certainly not consistent with ownership. We need a path there so that we could get up there with a free, unobstructed easement, as the court found. So that's our positioning by way of an opening. Going through this, I think Mr. Culp would have more to add to his declaration here, but that's it primarily, and we could always bring in Mr. Henners or whoever else if the court wants to hear some more testimony.
Very good, thanks. Mr. Conway?
Yes, Your Honor. So the much, I guess I'll try to. Much of this has been. There's kind of this blending of, things that they're alleging violates the current court ruling, or at least discrepancies, and then also kind of expanding that ruling. I think the DNR and the removal of the berms, at one point their expert says, 16 feet is needed. So, those types of things are in expansions of the court ruling, which I don't think is properly postured. The court had heard all of the evidence at trial and made a ruling. So I don't think it's appropriate to try to enter another expert report when the chance for that is with trial. As far as the parking of vehicles, if log trucks are our guy says it's fine, we can pass, it's not within the 12 feet that the court ordered. My client doesn't mind if log trucks are going to be there, or they're going to be there during a week or anything like that, moving those items. We're not trying to get into a turf war or prevent the logging at all. Our concern is that, with the court's ruling, the court has ordered the roadway in the distance of the roadway. I don't want to have a situation to where, we're getting back to kind of backdoor litigating that area, because my client has rights to use it. The court said they have rights to put up the cone. They have rights to put up, log things outside of the area. If one of those are in the area, we'll gladly move that. And so that's our pressing concern with all of this, is that we don't slip into relitigating the case. And frankly, if there's things that if these, if he has a right to park, I'm looking at this white truck or this trailer again. Hey, we're logging next week, could you move those? That's fine. Or if the court says, hey, it's got to be at least 12 feet, we'll make sure it's out of 12 feet. But I don't want to have this, another bite at the apple, as it were. And that's what it kind of starts to feel like when we have these, reports kind of readdressing the beam and the width and the, trying to get 16 feet instead of the 14 feet with the trees. And so the court has already made up its mind on that. And so that's kind of, I guess, our opening position, as it were, on our take on the situation, Your Honor.
Yeah, okay, so I'm looking at conclusions of law number 5, where it says the roadway easement shall consist of a minimum 12-foot running surface extending vertically, so that the trees must maintain not to encroach into that space. And so that's the way I review it. So we've got a 12 feet here along the horizontal line, and then we've got straight up lines, 90-degree angles that are going up that way, and there's no interference. That's how I read that. Like a box, if you will. So, okay. Well, and maybe I'll just cut this fairly short, because I looked at this fairly carefully in preparation today, and I'll tell you what my thoughts are on each of the concerns that have been raised. So the first one there, the first concern raised was the log placement near the corner by the gate. where it indicates that the log placement restricts the width to 19 feet, not the needed 26 feet. This is based on the court's indication that, there needs to be, commercially reasonable turning distances for logging trucks. And, I think that was understood that 19 feet for a big truck like that's just not going to be enough. And so I think that's a no-cost remedy to Mr. Spencer. So he needs to move that so there's at least a minimum of the 26 feet. And then the number two, the soft edge for vehicles related to the gooseneck flatbed and the flatbed truck where they're parked. And again, this is a no-cost remedy that Mr. Spencer can help with because the indication it doesn't allow safe passage. And so I think the indication was that by Mr. Conway that his client is willing to move those. And my sense here also, I think this needs to be stated, is that this easement, it needs to be open at any 24 hours a day. I mean, granted, Mr. Spencer can use the property, if he's actively using it, if he needs to reposition one truck to go move something over here, if he's in process, I get that. But just for parking and resting vehicles, it should not at all hinder the roadway easement. The roadway easement is 12 feet.
Okay.
That needs to be, a truck can pass by that, and that's what needs to be held open. There's a kind of a reasonableness to this aspect, and that's what I want to avoid. I really want to avoid nitpicking, and I'm a little bit frustrated that this even has to be brought up, because my intent in giving kind of this reasonable type ruling is to allow people to kind of work through these issues in a reasonable fashion. But then when I hear people kind of nitpicking, I really don't like that. And I really want people to kind of work through these issues and not come back to court. But so that's kind of my sense. So the third point, I put non-applicable. So then the 4A and 4B, the berm, I've already made that decision. The berm's not going to move. I recognize that there's potential for frame bending of both the truck and the tractor, or the trailer and the tractor, but they'll just have to be extra careful. And then the white truck near the roadway, indicating that causes too tight of a turn, makes it unpassable. That just needs to be moved to an area where that it does not cause obstruction of the passage using the roadway easement. The steel beam, that's apparently it's 11.5 feet, not 12, so it's encroaching upon the 12 feet of the roadway easement, apparently by a half of a foot, and there's a soft edge related to that, and it cannot support the weight. So that steel beam will need to be moved without the roadway easement. So it just needs to be moved. And then on the sixth one, the 16 trees, those will just need to be removed. They're low quality logs. They'll just need to be, those 16 trees as identified in the report will need to be removed. And obviously the 12-foot width and then the 12 just going straight up at a 90-degree angle, that'll be the area that needs to be kept clear and unobstructed. And so what I'm going to do, and I think in particular for the items that are parked and also the steel beam that's within the passage area of the 12 feet, those are really easy to establish. A 12-foot tape, you pull that out, you get the midpoint, and and it's really easy to tell whether you're encroaching or not encroaching. And here it appears to be that it's encroaching, and and this is based on prior findings of the court and hearing from the parties that there was some nitpicking, and there was kind of just maybe acting lesser than everybody should have been doing. So this is what I'm going to do, is that Mr. Spencer's incursion in the roadway, I'm going to make a finding that that's contemptuous based on the findings of fact and conclusions of law, and I'm not going to tolerate this. If this comes back before me, I'm not going to be as gentle as I am here today. So I'll make a finding of contempt. And I'm going to impose $1,500 as a sanction, and I'm going to hold in abeyance another $15,000 if there's not compliance. That can be brought back, and that $15,000 can be imposed. So Mr. Spencer just needs to make sure he moves the different vehicles and the other items that are obstructing out of the way. And so they're not there. But so I'll impose the $1,500, then I'm holding in abeyance another $15,000. and as a motivation for him to make sure that he does that properly and doesn't nitpick. That's the court's ruling. Any questions?
Yes, Your Honor. Are they removing those trees, or you want Spencer to?
As far as, is there any indication from the findings and the conclusions?
I'll look. I thought they could remove it. I don't think it's a huge deal, but I just want, if they're going to remove it, it might be better if they do it, because they'll, they're
they know what they need. Right. Yeah, and I think that's, to me, Mr. Fry, unless you have some contrary indication, to me that seems reasonable. If Mr. Culp is actively attending to logging his property, there's certain costs that are associated with logging, and that seems to be somewhat of a minor anticipated cost because trees do grow into roadways, and that's just kind of cost of doing business.
Mr. Culp and BD Culp's concern was the forced practice application, and I sent you that. I don't know what we could do to help out with any confusion. Like if I need a letter, I understand, I recognize counsel's position that, talks in terms of the owner operator or something like that. And the way I understood it, Mr. Culp explains in his declaration, is he was told that since Spencer's the owner, he has to sign that to allow DNR to come in there and inspect the operations and make sure he gets the forest designated forest land.
So that's what that signature means. It's authorizing DNR to enter the property. And I think as the landowner, Mr. Spencer needs to sign that.
Okay, I'll have him sign that. I just read through that, and it's talking about tax credits and monitoring. It's more about, I read that as the landowner of the trees. I don't think my client should be signing on harvesting activities on land that's not his. This is clearly, something, and we don't even have any testimony from the DNR that that's what this is.
Okay, well, we will do our best to follow up on that with the DNR. And it's a whole different system that I'm not familiar with. But,
yeah, and my sense is also is that the signature, by the terms of its language, is solely limited for the granting of permission and authorization to enter, inspect, and monitor.
I just want to make sure that Mr. Spencer is going to sign anything that's required for produce. I mean, I don't want him to sign a forest application. We're all in agreement here.
That's never been the issue.
Yeah, so let's do this. So as far as the FPA, Mr. Culp will fill out all the necessary information as requested by DNR. The default position will be Mr. Spencer signing where it says signature of legal landowner, with the understanding that that's simply authorizing DNR to enter the property, inspect, and monitor compliance. If then as a secondary, if the parties want to do this, you can do this, but if you can't agree, then Mr. Spencer signs. But the secondary option would be submitting a declaration that Mr. Culp has given notice and that Mr. Spencer's fully aware of what's going on. So those are the two options, and the default is that Mr. Spencer signs.
Okay.
So I'm making a finding that there's contemptuous behavior by the number one, the corner by the gate, the log placement restricting the width to 19 feet, not the 26 feet. The gooseneck flatbed and the flatbed truck, the parking position, I'm making a finding that was a violation of the court order. The berm, that's not violative. The white truck near the roadway causing the light turn or tight turn, making it unpassable, that's a violation. And then the steel beam being within the 12 feet, that's a violation. And the 16 feet, that's a violation also for contempt. And so then the court's imposing the $1,500 sanction, holding in abeyance the $15,000 to ensure that there's compliance with those items that were found to be violative and correcting the same.
And how long do we have to do that, Your Honor?
I think, but he wanted to get it going as soon as possible. But I assume the next 2 weeks we're in that holiday and then this storm recovery. We've got a lot of trees down, and I know it's a mess out there for everybody. But.
Let's see. So today we're the 19th. So I think the work needs to be done by the 16th of January to come into compliance. The corrective actions related to the contempt need to be completed by the 16th. And I don't think it'll take that long because basically it's moving things. The only thing that might take a little bit of work is that steel beam and the trees.
Yes, but they're doing this.
Taking care of the trees.
Yeah. Okay. All right. And that should work fine, Your Honor. Thank you.
So that'll be the compliance of January 16th.